What's up? Isaac here, reporting on my lunch break for my new channel, The Unorthodox Social Worker, where we do talk about all things social work from an unorthodox perspective. So for those of you that didn't catch my first video, before that I'm reporting live from San Francisco in the Fillmore district. So if you didn't catch my first video, just to give you a little bit of background information on myself, like I said before, I do not have any college experience as it pertains to social work. I do have a BA in music production, but not anything to do with social work. I've been working for about the past decade, mostly in homeless services. I have run educational programs for homeless youth. I've worked in housing homeless individuals on various grants. I've been a social worker, a case manager, an outreach worker, a case management social work outreach supervisor. I have done a little bit of job development, getting people jobs. I've worked with populations such as the youth, such as military veterans, and people on probation. Excuse me. So off to the topic at hand today. Confidentiality is key. And yes, confidentiality is key. Don't forget that. We have to protect people's data and personal information. And in my opinion, to all new social workers or current social workers, everybody should have this training very early on and get frequent refreshers on confidentiality, because I do see a lot of people in the field riding the line or making mistakes and putting themselves at risk of liability as relating to clients' personal information. So when we talk about confidentiality, we're talking about protecting clients' personal information. So what could personal information be? This could be names. This could be social security numbers. This could be any type of other numbers, such as phone numbers, emails, any other type of contact information, street address, postal address, any type of eligibility info pertaining to that client's case, anything regarding to any of the types of services your client is accessing, any type of demographic information, such as, the gender, the weight, the height, the race, and of course, health information. So this is kind of like HIPAA, and even a lot of social service agencies are required to participate with HIPAA. So if you work in the medical field, you do know about HIPAA. That stands for the Health Insurance Portability and Accountability Act, which was put in place so that both medical agencies and medical insurance companies are not allowed to share any type of personal private health information without the permission of that patient. So again, this personal information, when you're dealing with your clients, any of their personal information, it is your duty to keep that, in most cases, between you and the client. You are not allowed to divulge this information to anyone else or any third parties. However, there are some exceptions. So that's going to bring me into the three instances where you are actually able to disclose clients' personal information. The first would be suicide. So if your client does say they're going to commit suicide, then it is actually your duty. It is mandatory that you report this. Well, first, you have a conversation with that client and make sure they're okay, and hopefully guide them to some type of stability in that moment. And whether you're the person that will be counseling them for suicide, or you will be referring them to some hotline or other agency or other worker, in that case you are able to divulge a client's personal information. The second case would be if the client is threatening bodily harm upon others. So if a client is threatening bodily harm upon you, another client, a staff member, anybody, in that case you would be able to disclose that personal information, usually to some kind of law enforcement, that this person has the intent to commit bodily harm. The third and final instance where you would be able to disclose a client's personal information would be if you your client is in litigation and you do receive a subpoena from the local courts um, to surrender your case file to the court, and you may even be subpoenaed to appear at the court personally to testify in whatever case this may be. In that case, you really have no choice. It is the law, if you are served a subpoena, to comply with all requests from the courts. So those are the three instances, pretty much only where you're able to disclose any personal information outside of your ROI. Which kind of brings me into how I'm going to be doing this channel. You'll notice I'm not really going to be telling any specific stories, because any story I tell that is a specific or targeted story, that's something that actually happened, it could have a client's personal information in that story. So I will be speaking on this channel in the most general terms possible when talking about cases or what you may encounter in social work. I will never disclose anybody's personal information on this channel. So just keep in mind when I'm talking about that, I will not be talking about specific cases that I have had, and rather will be speaking on a more general term in order to help protect any data or personal information of clients that I've worked with in the past. Which brings us back to the ROI. So anytime that you are doing an intake with a client for your program, or doing perhaps some type of paperwork, you are going to be having them sign an ROI, which stands for Release of Information. On this release of information, you will be explaining to the client that it is a confidentiality notice, and it will usually typically let the client know that all your information disclosed about your case to you as the social worker or whatever role you have, that the client's information will be confidential and only shared between you and the client. Now, in many cases, there are clauses in that ROI that says that the data may be shared with other staff members within the agency you work for, and perhaps maybe whoever the grant funders are, whether it's the government, whether it's a private entity, that your information may be disclosed to them for data purposes. So usually, pretty much most of the cases I worked in, that is in the ROI, that you are able to share information amongst the other staff and with your grants funders. Okay, now there's other instances where your information could be shared with other agencies. Now, anytime that your information is shared with another agency, that agency will be listed on the ROI. So let's say you're working on a housing program. Maybe the people who fund your housing program may also fund a job development program. So it will list that job development program on the ROI, and you are going to want to explain to your client before they sign it that, look, me, the agency I work for, and all of these other agencies listed will have access to your personal information, and they have to understand that. Now, they do have the option to decline to sign that. So if they do decline, that means you can't really share it with anybody besides yourself. So keep that in mind. A little story about that, and remember, this doesn't really have to do with a specific client, but when I did work with people who were on probation, the probation department of the particular county I was working in was on my release of information. So I was able to share information about my client's case with the probation department in that county. Now, the local law enforcement in that jurisdiction was not on my ROI, so I was not able to disclose any information to local law enforcement of that jurisdiction. And believe me, I got calls all the time from that local law enforcement asking me personal information about my clients and perhaps their whereabouts, and I would have to tell them I can neither confirm nor deny any information about this client, because I was not able to speak with them because they were not on my ROI. If I had told this local law enforcement, this police agency, that would have been a breach of confidentiality. And that kind of goes into, just say you're a caseworker, and then you get a call from some other agency or another caseworker somewhere else, and they're saying, oh, blah, 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 I'm trying to find information about one of our mutual clients. If that person or that agency is not on the ROI that you had your client sign, you cannot talk about anything about that case with that other worker, even if they do in fact work with that your client as well. And this is a mistake I see all the time. Other agencies, entities will be calling you, asking information about one of your clients, and they're just kind of willingly giving up information, whether it be personal information, whereabouts, anything else about that client. That is a rookie mistake I see people make all the time. That is a clear breach of confidentiality. So you remember, if anybody's calling you, asking you about a client, you have to say, I can neither confirm nor deny anything about this client because I do not have permission to speak to you. But you could say something like, however, if this person is here, let me get your contact information. I will give you that phone number if they are here, or I do have contact, and they will contact you back. So that's kind of a way around that. You never want to let any other agency know personal information unless they are on that ROI. And that just goes, just have people sign off on everything. Which goes into the second part about this, or third, or whatever, liability. If it is found that you have breached your client's personal information, not only can the agency you work for be held liable for that, you could be held personally liable. So that client can take you into litigation and hold you personally liable. From the research I did, it's about the max like 250 grand in fines. And don't quote me, but I also think I read that any financial damages that were incurred due to the negligence, or the, say you let some data get out, somebody else saw their name, their social, their address, their birthday. Let's say they go out, this person fraudulently applies for credit cards and racks up, 10, 20 grand in bills. You may be held personally liable for that 10 or 20 grand on top of any financial penalties that max 250 grand. And I'm not sure if there's any jail time, but there is a major financial liability, and then the liability of your reputation. Once you are caught breaching and sharing or letting other people see clients' personal information, your reputation will be ruined, and if anybody knows you did that, you probably will not be able to get a job within the field. So some strategies to avoid breaching data. The first one, which I see all the time, please, if you are speaking about anything regarding your client's case with your client, please do not do it in front of other people. So, if you are in a common area, a lobby, out on the street doing street outreach, any place where other clients are around, random individuals, or even other staff members are around, you do not want to just go ahead and start talking to your client about their case, because there's people around that will be able to hear all the information you're talking about, which is personal, confidential information. This is a mistake I see all the time. If you are going to have a conversation regarding your client's case with your client, and let's say there is no space where you can have a private and a confidential place to discuss this information, you're going to want to at least verbally ask the client. You're going to say, hey, do you mind if my coworker is in the room? I will be asking you personal and confidential questions. Do you mind if the coworker is in here? Or if you're in a common room, do you mind if other clients or residents are around here? We will be talking about personal information. Or if you're on the street, do you mind that we're out in the street and other people could hear this conversation? You're going to want to get their permission. If they give you a verbal confirmation, yes, we can go ahead and have that conversation. That's usually enough that you would need. And then proceed to have the conversation there if you have a verbal. It's even better if you get something in writing that states that they give you permission to talk about personal and private confidential information in a public space. Say like I said, your file gets subpoenaed and you just got a verbal confirmation and they're trying to tell you, oh, this caseworker was talking about my case in public, and you simply said, oh, I had a verbal confirmation. That might not fly in court. Um, so ideally, get something in writing, a new ROI that you can make yourself that says, I'm allowed to talk to you about personal, private, and protected information in a public area. Okay, so again, do not speak, and I see this all the time, do not speak with your client in public areas around anybody else. Find a nice private space. Maybe use one of those white noise machines, which makes it even harder for other people to hear your conversation. Now, as far as data goes, and physical and digital data, there's going to be a two-step confirmation process. So anytime you are accessing data, you're going to have two locks before you can get to that data and private information. With physical stuff, case files, you're going to have the first step, the key to your office door. The second step, the key to your file cabinet. So again, make sure all your files, all personal information is stored in the file cabinet. Just don't have people's random personal information posted on your wall, plastered on your desk. Anybody can walk by, take that information, and do bad things with it. So that you want to keep it locked with two steps. The first being your door, the first being your file cabinet. Anytime you are out of your office, lock your door, lock your file cabinet. With digital data, this will go into things such as passwords. You're going to want to have at least two passwords to access that data. The first one being your computer password. The second being the password to the database on whichever you access and enter data into. Remember, do not save your passwords because that just leaves your data open for anybody to go in there and access that data. If you happen to leave your desk, turn off your computer monitor. Put your computer to sleep so somebody will have to log into that computer again to gain access. Again, I see this all the time. If you're leaving your desk, put your computer to sleep. And again, do not save any kind of passwords. If you are in public, if you're in a cafe, don't be doing any data entry in a cafe because people can walk behind you, or in your restaurant, they can see all this personal information you are working with. If you have to put your data in public, get one of those things. It's like you can put it over your computer screen and it prevents people from different angles looking at your screen. So if you have to put data in public, use one of those screens. And back to the last part, if you do see your client walking around that you've worked with in the past, regardless of how good your relationship with them, don't just walk up to the client and say, hey there, so-and-so, blah, 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 you remember me? Because perhaps that client may not want to talk to you. They may be hanging out with friends who are looking at you like you don't look like nobody that this client would ever hang out with. And then they have to go explain that, oh, that's my case manager from so-and-so, and you're causing a breach of confidentiality, or you're making the client feel comfortable. So if you ever do see a client in public, wait for them to say hi to you first. If they say hi to you first, then boom, it's fair game. Go ahead and say what's up. And if you want to have any type of personal, business, romantic, any type of relationship with an ex-client, you're going to want to wait. At least most agencies will be like 6 months to 2 years. Every agency usually has a policy about this, but if you're going to be doing anything personal with any one of your clients, you are going to want to wait until that period has ended, whether it's usually about 2 years from what I've seen. So if you want to go kick it with a client, wait 2 years, or else you would be going against the policies and procedures of your agency. So that's pretty much it. I hope you got a nice little overview of data and how important it is to keep your data clean, confidential, and secure. Please use these tips. Do not, fall for the traps, because you can be holding yourself liable for something that you would not want to experience, such as financial liability. All right, y'all. Thanks for tuning in. Don't forget to like and subscribe, and we will see you again next week. Deuces.